We will have a very quick review of, what is relevant, mostly in the UPC agreement, but also in Brussels regulation, when you think about what you can do during the transition period. And I think really the purpose of the topic is, you are ahead of a transition period, which is 7 years. It may be 14 years, we don't know. And the question is, you will have this option first. You will listen to Willem. You will not opt out. So I'm discussing now what will happen if you have EPs, European patent, which have not been opted out. Obviously, if you've opted out, you're out of the system, national court, no question. So I'm really addressing the question, you've listened to Willem, you have not opted out, and so what happens? And really the question is, how do you choose the national way? Is UPC better? What happens if you have a national action? Does that have an influence on UPC action? Can you block as a defendant the UPC action? That's the question. So let's go very quickly over the relevant provision. And I will be very quick because I think Marina really went through a number of them. So very clear, the UPC will be, at the end of the transition period, the only court for European patents. But in between, during transition period, European patent could be litigated before the UPC and national court. But we have unclarities, and that's the main issue. The first lack of clarity, and I've been discussing this morning with Willem, who tells me, no, that's very clear. Well, I'm not even sure that's, so clear. But let's say there's an uncertainty. The first uncertainty is regarding the wording of Article 83, the one which provides that during the transition period, you have a competing jurisdiction competence between national court and UPC. And the first uncertainty is that the Article 83 says that during transition period, you can start an action for infringement or for revocation of a EP during national courts. Well, the question is, does that mean that for the rest, we must go to the UPC? Because you can see that the list of actions that Marina presented, which can be launched before the UPC, which at the end of the transition period we have an exclusive competence for, is much longer. And it includes action for declaration of non-infringement, those very provisional measures we've been discussing. So does the wording of Article 83 means that you can't do a declaratory action before a national court any longer? That's the question. Willem disagree. I'm saying that, we will have the issue, that's for sure. Next question. You have this rule in Article 34 of the UPC agreement, which says that when you bring a case for infringement before the UPC, the decision of the court shall cover the territory of those member states for which the European patent has effect. And so, yes, so does that mean that if you bring a case before the UPC, you get an injunction for the entire countries in which the European patent has an effect? Or does that mean that, at least, and that's the question and the cross-reference with Article 76 of the agreement, which says, well, but still the party really, the claimant, has a control over the requests which are submitted to the court, meaning that it is to the claimant to tell the court, well, yes, I have a European patent which has effect, let's say, in Italy, Germany, the Netherlands, France, Portugal, but you court, you UPC court, I just ask you to make a decision with respect to, I don't know, Portugal and France, but leave the rest out. Is it possible? We don't know. Next question. We do have a number of rules in the UPC agreement. We know, what will be the applicable law, and you can see that Article 24 is comprises a list, and it must be read in that order, meaning that EU law is at the top, then you have the UPC agreement, then the European Patent Convention, an international agreement, including Lugano Convention, for instance, and then you have national law, which is at the very bottom, as you can say. And then you have substantive rules on infringement, which seems to be very similar to the one you have, but mind the fact that you will have some differences. And for instance, the Bollard exemption is not exactly the same, at least for my country, France. The Bollard exemption, meaning the exemption of the acts which are committed to prepare for the grant of a marketing authorization, it is much narrower in the UPC agreement than it is in my national law currently, because it is not limited in France currently to generic, while in the UPC agreement it is clearly limited to generic. So yes, just remember that the UPC agreement, which will be applied by the UPC court, has rules which may be different than the one which would be applied by a national court. With another question, and then I will go to the various scenarios, which is, I mean, do you expect in your country that the national law will be aligned with the UPC agreement? I can say that it is the case in France, meaning that on the day on which the UPC agreement enters into force, our national law will be changed to be reflecting the rules of the UPC agreement. So the national court will have exactly the same basis to decide on a national infringement than the UPC. I think it's the same in the Netherlands. No?
I think so. But is this also with respect to the border exemption then?
Yes.
Okay. So we can forget about that difference.
Yes, but at least for our countries. But,
yes, but
it may not be the case for the other ones.
For Germany, for instance, because Germany has the same
yes.
as you have.
Yeah.
Okay. Yeah,
Last.
Let's face it, a normal judge is not going to do something different, isn't it? Okay, go on. Yeah, there are not so many normal judges. Okay.
Well, yes. Last slides on the rules. Last one, which is really interesting, is, and I think, Marina, you addressed it already. I mean, the court, the UPC court will be a court common to the member state, meaning that it is the equivalent of a national court. And what is really important is that during transition period, the UPC will be treated as a national court whenever you have to assess lease pendants and relatedness, meaning can you bring two cases before the UPC and a national court which are similar cases or even identical cases. So, yes, maybe I'll skip the relevant case law of the Court of Justice. I'm sure all of you know it by heart. So, then scenarios. Be careful, I'm asking questions. First scenario. We have a generic company, let's say A, which files an action for declaration of non-infringement of a European patent, let's say in Italy, in the Netherlands, and in Germany. So the first action is a deny. You remember, I think the first question is really, can we do this? Because we're not sure, given the drafting of Article 83. But let's say it's possible, and that's William position. Then B, which in our scenario is the patent holder, files an infringement action before the UPC. And this action for infringement covers all UPC countries, including Italy, Germany, and the Netherlands. What does the UPC do? Does it stay the infringement proceeding pending the national decision on non-infringement? Does he carve out the three countries in which you have a declaration of non-infringement pending, meaning Italy, Netherlands, and Germany?
Go
on. Nice try. So maybe the reply to the first question. It will not stay the proceedings, at least with respect to Italy, to the rest of the countries, meaning, all the countries which are not Italy, Germany, and the Netherlands. And yes, it can carve out the claim for infringement, meaning that the court can decide that it will not make any decision on the 3 countries in which a first case was filed, which is clearly an identical case as the one which would be brought before the UPC. And, you know, it is an argument which has been tested with the judges, including in Budapest. And I think their reply was very clear. This kind of national action, which could be seen in the past as a torpedo, will no longer be a torpedo. You can start as a defendant a declaration of non-infringement before a national court, but that will not stop the UPC in an infringement case, at least for the rest of the countries. Yes. Going to scenario 2. I think this one is really an alternative to the first one, in which you have a revocation case, which is started as a first round of national actions by a potential defendant in infringement proceedings, and then the patent holder responds merely by filing an infringement action before the UPC. And so again, the question is, what would be the effect of these revocation cases started nationally? And, well, we can say first that that doesn't create list pendants, because really the subject matter of both actions would be different. And the question as well would be, you know, would that really affect the infringement proceeding? Would the UPC be willing to stay the infringement proceeding pending the revocation action? I would say likely not, even for the infringement of the, in that case, Italian, Dutch and German part, because even if you have a counterclaim for revocation before the UPC would assess the validity of the patent, at least for the other designations, and would have, I think, quite a clear idea on validity. And I would say that if the UPC judge is convinced that the patent is valid, it is very likely that he will not wait for the outcome of the revocation proceeding nationally to grant an injunction, even for the Italian, German and Dutch designations. So once again, you can see that the national action wouldn't be blocking an infringement action before the UPC.
He may give a conditional
True.
injunction. So conditional injunction, sorry. He may give a conditional injunction in the sense that he says, okay, this injunction for these countries is valid as long as the patent stays valid. But so if it is invalidated in the Netherlands, then the injunction would fall for the Netherlands.
Yeah.
I think that would be the smartest solution to this problem.
But still grant injunction.
Yes, absolutely, always. If there is an infringement, of course.
Yeah. I will not go through, the last paragraph, but just remember that, you know, to address this situation in which an injunction can be granted, pending a revocation action, of course, as a defendant, you can ask for a security because you still run the risk of being injuncted while the patent may be later revoked. So you can request a security. And if indeed the patent is revoked, you can obtain damages that arises from Rule 354. Going to scenario 3. In that case, it's rather the patent holder which, start the case first, and it starts an infringement action in Italy for an infringement in Italy, just because, it's at a stage of the proceeding where there's no infringement anywhere but for Italy. So it's a national case. As a reply, the defendant starts a central revocation action before the UPC. And so the question is, what does that revocation action has as an effect on the Italian proceeding? Well, again, it's not lis pendens, because it's not the same cause of action between the two proceedings. So the question is whether the Italian court would find that, it's relevant to stay the infringement action in Italy pending the revocation action before the UPC, but at least that's not a true blocking effect. Last scenario is another one in which we have a PI, because I thought, I need to have a slide with a PI for Willem. Thank you. And then in that scenario, you have a patent holder who files a UPC-wide preliminary injunction action before the UPC against defendant B. And the question is, what would have an effect? What would be the effect of B filing a series of non-infringement action before the biggest market for him, which could be Italy, Germany, and the Netherlands? Well, clearly that wouldn't be lis pendens, because there can't be lis pendens between preliminary injunction action and action on the merits. So the declaration of non-infringement wouldn't have a blocking effect. But the question that arises is really, what happens if the PI is granted by the UPC, and then you have a rule in the rules of procedure, which I think is coming from the enforcement directive, according which once you get a PI, you have to start an action on the merits within 31 days. And the question is, where do you file your action, at least with respect to Italy, Germany, and the Netherlands? Because you have an infringement action pending already. And so we discussed the two options, William and I think we have mostly one safe solution, which would be to start an action for infringement on the merits before the UPC, knowing that at least for the Italian, German, and Dutch part, there may be lis pendens, and so you may reach the point where the UPC would say, I don't have jurisdiction because this infringement is already discussed before a national court, but at least you would have a statement of claim which have been served within 31 days, meaning, you met the deadline which is required by Rule 213. The alternative, which is a bit less safe, would be that, you take the position that you just start your infringement action before the UPC for the rest of the contracting member state, but you say that, the action which is already pending in Germany, Italy, and the Netherlands is in fact the action on the merits which validate your PI. But you can see again that, the declaration of non-infringement would have no effect on the PI which is granted by the UPC. So that concludes my presentation, which obviously only, address 4 scenarios. I'm sure we will have many others, but I think really the conclusion I wanted to have with you is that, we thought when we saw the transition period that we would have, as a defendant at least, a vast range of options to block the UPC. I think what we see now, that we really think about what we could be doing in a few months, that, there won't be many options for the defendant to really block the UPC. And what we've heard from the judges, even in Budapest, is that they are more than willing to avoid being blocked by national courts. Even the national court and the UPC applying properly Brussels regulation and lis pendens, and in conformity with the case law of the Court of Justice.
No problem. Very much.